we're joined by also a practitioner from HSBC, Cameron Craig, Deputy General Counsel, and also Anthony Lee, who's a partner with the firm, outside counsel with the firm DMH Tellard, right? So our approach here with this panel will be that each of our panelists, our two new panelists, will offer a couple of key issues. They'll introduce themselves, their background, and a couple of key issues. So I'm going to ask that the audience also please put forward any issues that you may have that you would like to see the panel address, and then we'll have a moderated discussion and share some key takeaways with you. So, Cameron, how about if we start with you, if that's all right?
Yeah, thanks. Well, my two issues I would like to raise very much resonate with Jonathan's presentation. I think complexity would be the headline for my first issue. I think both in terms of the GDPR itself, once again, completely echoed Jonathan's comments that the law was in need of update to reflect the modern technology. My sort of challenge would be whether the GDPR actually does that successfully and in a way which is clear. It does contain a lot of good positive things, but my view, as I've been saying this for a number of years now, is that it would have been a lot better to be absolutely clear what's changing. But if you read the GDPR, many of the obligations and requirements are really consistent with the existing law. The basic principles are still the same. And what's really new, as was highlighted by Jonathan, is the obligation is the accountability. You need to demonstrate that you comply, which I think is a good thing to make organisations focus on what they need to do and to get their house in order. And also the enforcement regime obviously has changed. There are a number of other things which you could say are represented in the existing law, but it's good to highlight those. But I think the additional complexity of, rather than focusing on exactly what's changed, the lawyer in me would like a sort of delta view, if you like, markup of the original law. But I think there's that complexity. The other aspect of complexity is also very well highlighted by the sort of roadmap Jonathan portrayed. One of the key drivers for this was harmonisation between EU member states' laws, and you can see now with the different approaches being taken to derogations and the slightly different implementations, I do wonder whether we will achieve that harmonisation between member states, which is so key for businesses. The other area, you could raise about 20 issues really, but maybe one of the other areas worth sort of mentioning, particularly when we've got Jonathan here, is the ongoing influence of the ICO in European data protection law. I think that many of us that have been involved in this area have seen the UK being a very positive, moderating, constructive influence on the Article 29 Working Party and a lot of the developments. And certainly, from my position in industry, we would very much hope that this engagement could continue.
Okay, thank you very much. And also, if Anthony, if you would care to just briefly introduce yourself and provide some.
Yeah, so I'm a partner in a law firm called DMH Tellard. I'm primarily an IT lawyer, and over the years, the whole data protection and privacy piece has been taking up increasing amounts of airtime. And as May of next year approaches, that seems to be picking up momentum. A lot of what I do is in the contractual space. And as a result of that, a couple of areas that I thought would be good to focus on in a bit more detail, and were indeed touched on in the GDPR panel yesterday, was one of the areas where there's a lot of change is when you're appointing third parties to process, if you're a data controller and appointing third parties to process data, there's quite a lot more stuff in the regulation that you need to abide by. And also in that context, because we live in the world of the cloud and there's a large element of servers being based outside of the European Economic Area, in that context, also a little bit of a look at what the rules are in place in relation to export of personal data outside the European Economic Area, which has actually been called out by the regulation as an area that can attract the highest levels of fines, the one that says up to 4% of global turnover. So I thought it would just be worth spending a bit of time looking at that aspect, and also get some input from the delegates as to what their experience of that is to date.
Yeah, it's a very interesting point. I often wonder how that's going to be enforced for some entities outside the EU as well. I can just see the Sudanese, oil and gas company or something saying sorry, but we're not necessarily going to pay the fine or whatever. But be very interesting. Also. Just to sort of come back to this point of complexity, which came up yesterday, and you brought back up. I've looked at this and say, wouldn't it be great if we could take the complex and just make it merely complicated, and so that we could at least put a process around it. The challenge here, though, might be at HSBC. What are you doing as both a data controller and a data processor, right, to put some process around it? I'm sure you already have processes. Is there anything kind of new that you're being forced to do?
I think it is good. I meant to say this at the start, actually. It's quite interesting. I was, before joining HSBC, like Anthony, I was a partner in a private practice law firm, DLA Piper. And whenever the GDPR was first published, I think, this is great. It's, lots for us to get our teeth into here, and must phone up the clients about this. But it wanted it to be, complex. So there's lots for the legal people to do. But now I'm in-house, as you say, we're trying to, what businesses need is clarity and certainty, so that they can actually build what's needed to execute for GDPR. And there's a train coming down the road, of course, coming down the rails, of course, May 2018. And we're very much focused on execution and just doing the basics of what we need to do for a good level of compliance. We've been speaking with regulators, including the ICO, and the sort of message that we get back is, focus on good practice, because there's so much noise out there around the sort of intricacies of all the different articles, and now with the DP bill, there's different interpretations, and we're also heavily engaged with other forums to try and get resolution of those. But the basic principle is, within the financial services sector, we need to do some things with data in order to comply with our regulatory obligations. And that does include a degree of monitoring. It does include a degree of sharing of information. We do, or strive to do this in a proportionate and reasonable manner. And the feedback we've had from regulators is that you should continue to do this in a proportionate manner, despite the fact that you could have a legal argument around some of the principles that actually this is going to stop you fighting financial crime, and this means that you can't screen transactions because of whatever interpretation. And these differ between the different strands, which makes it very complex. But we're focusing on practical compliance. What do we need to do? The ultimate obligation is to treat individuals fairly in a transparent way. And many of the obligations actually chime with a lot of the other themes in financial services sector, such as the conduct agenda and looking at outcomes fair outcomes for individuals, putting in place operational risk frameworks to manage risk effectively. Many of the things the GDPR requires are actually very consistent with the other drivers we're putting in place within the financial services sector.
Okay. Before we continue here, are there any issues or questions that are top of mind for any of our attendees? Just, raise your hand if you have something at this point. I'll come back to you. We have a gentleman right up here at the front.
Thank you. How will the current laws deal with the evolution of, the commingling of data and artificial intelligence? So at what point is it still data versus a system, at what point does it become commingled and you no longer know what is your data versus derivation of your data?
Yeah, that's and I'll thank you. We'll get to that. That's a good one. Anything else that people would and have another item back there? That's a very good point, by the way. So I'm going to try and bring all of these issues up as we go through in the discussion. Right back here.
I wonder if you could comment a little bit on your belief of what will happen vis-a-vis the United States. Safe harbor has been set aside, and there's significant speculation that Privacy Shield will be set aside by a European court. And if that is set aside, what do you think will happen as far as data sharing with the United States, and how can that be provided?
Very good. Okay, thank you. Thanks. Anyone else at this point? We'll come back. All right. Okay, so let's continue with our discussion here. Jonathan, you've heard some of the questions here and the issues around complexity. I noticed that you started out very much trying to demystify the UK laws versus GDPR and the various new regulations that have emerged from the previous directives. Is there actually a shift here from sort of a principles-based approach to more codification and enforcement, or a role change from the supervisory authorities from more of an advisory role to we're going to slam you for any violation that you have?
Okay. I mean, I think you're right. There's been a bit more of a codification of things.
Right.
I'd just say it's as more as a particularization of certain elements, really,
right.
in the GDPR. And clearly, the sanctions regime is one which is set out in much greater detail than in existing laws. And indeed, to be fair, as I alluded to in my presentation, we had to change our own existing data protection law to include new sanctions that fit the crimes, really, that were starting to be committed. So we have seen something there where you've got a much more specific regime. Though having said that, within that there is still discretion on supervisory authorities in how they undertake their tasks and what emphasis we give to things. So, as somebody who may have dealt with various data protection authorities in Europe, you might see how some of us operate our functions in slightly different ways. Some are much more keen in terms of auditing people and finding non-compliance and then levying penalties on people to help with their income streams. That's not a business model that we adopt in the UK. We have a very different system, in terms of doing that. But certainly, you're starting to see more things in that regulatory mix for us now, and more requirements to have these in there. So I think it has become more of a proactive regime. But equally, the thing that I would want to happen, and I think with accountability and those sorts of concepts, it's slightly disappointing that maybe it didn't go as far as it could, because that's really about incentivizing people to do the right thing in the first place. So for me, what's the regulatory reward for the people who do the right thing versus the people who don't do the right thing? Well, clearly when we're issuing penalties, we can take that into account in terms of those levels. But I think also, can there be a slightly lighter regulatory touch with those people who adapt those sorts of accountability principles? And I think that was the basic idea there. Whether that's as well delivered in practice is another issue.
Right, yeah. So, Anthony, you brought up the third-party issue, and yesterday we had, you were there when we had, two significant data processors here on a panel. It seemed like they had both of them had a fairly strong approach. Deutsche Telekom in particular seemed to be extraordinarily rigorous in their data protection regimen. So what are maybe some of the emerging issues, though, when you look at data processors and third parties?
Well, I think really probably to set the context, because as Cameron says, there's a lot that's the same. There are some material differences around accountability and transparency, but a lot of it's in the current regime. So firstly, the definition of processing is very wide. So it's not just the classic storing of data by a cloud service provider. It can be any third-party organisation that touches the personal data in some way. That can be merely retrieving or accessing the data. So I think it's useful to put that in context, although the examples I'll give will probably be in the cloud area, because that's the area that I think attracts the most concern, and rightly so. And secondly, before you even get into looking at what the regulation says about what needs to go into a contract with the third party, which is in Article 28, the controller, for example, the retailer, has to satisfy itself that it actually has the right to share the data in the first place. And Jonathan mentioned the fair processing conditions, or what are being called the enhanced fair processing conditions under the regulation. So one example might be that you've got the consent of the data subjects, and again the flip side of that is that the consent can be withdrawn at any time, and you need to tell the data subject that they can withdraw that consent at any time under transparency. You may rely on the one that's been leaned on very heavily in the private sector, which is it's necessary pursuant to the legitimate interests of the data controller, which will no longer be available for public sector bodies, by the way. So you need to first establish that you have the right to share the data. And then the next step is that, in line with the accountability provisions, you need to satisfy yourself that the third party that you're going to entrust with this data has indeed got the technical and organisational measures in place to protect the data against the sort of external threat of hack attacks, or the internal threat of people accidentally walking out the door with data on unencrypted hard drives and so forth. And then once you've gone through all those hoops, then there are a whole bunch of contractual promises that you need to extract from the third party in question. Now, the current regime in the UK, there are only two that you need to extract. One is that the processor will follow the instructions of the data controller, and two, that the processor will have the technical and organisational measures in place to protect the data, the points that I just mentioned. And then there's a whole bunch of stuff that's in there. And I think actually a lot of it's a matter of common sense, and frankly should be in there anyway if you look at it. And actually a lot of it resonates with what you see in the financial services sector, for example, with the FCA's handbook, Systems and Controls handbook, or cloud guidance. But I'll just go through all of them. I'm not going to list them all out, but one of them is that the processor has to be in a position to provide to the controller the information that it needs to be able to demonstrate compliance to the regulator, the accountability side of things. The one that certainly the cloud service providers understandably have pushed back on over the years, in a right to be able to inspect and audit those facilities. Now it says you have to have it in the regulation, so I think that will rather clarify that particular issue. There has to be an obligation on the processor to return or delete the data at the end of the contract. And again, depending on where you are in the sort of bargaining position, you might want to put a bit of topspin in there and say, well, actually, we want the right to be able to grab the data at any time, and if you don't cooperate, we can go and cart it away ourselves. So, you'll have kind of developments of those particular themes. All sorts of provisions around cooperating with the data controller in the context of security breaches and so forth. And I said I won't go through all of them. But the other one, which I think that has been largely forgotten, and probably should be in there in most contracts anyway, is that the processor, for example, a cloud service provider, isn't allowed to appoint a sub-processor. So, for example, a software as a service provider using the Amazon cloud or the Azure cloud at the back end, they're not allowed to do that without the consent of the data controller. And all those clauses I just mentioned have to be flowed down. So, it's a very different dynamic to the way it has been before. And it obviously begs the question about what you do with existing contracts. And there was discussion yesterday, I think, with Verizon had developed a playbook and they'd hired a third party to go out there and try and renegotiate those clauses.
It also begs the question as to how realistic some of those requirements are, particularly getting consent to sub-process and getting rights to audit. If you're talking to a big cloud provider, I guess it might be quite a challenge to negotiate those things.
And I think actually I had one yesterday where when I asked the client the question about what they did with this and that, they said, yes, well, we're using Microsoft 365, which means Azure. And I'm afraid with those, they're just going to have to wait and see what kind of statements Microsoft come up with in advance of May of next year and hope that they will get their ducks lined up. I suspect they will.
But from the point of view of a cloud services provider, it's almost impossible for them to say, we will get the consent of all of our clients before we subcontract any of our services or hold our data.
Think so.
And I think that's one of the areas where I might be a little bit sort of critical of the GDPR, that it's not really focused on what actually happens in business, and it could be updated. Because one of the areas, for example, could be progressed, and I think there's still scope to do this, is a sort of code of conduct, for example, so that there will be sector-specific codes of conduct in the way that you handle data, which could be extended to cloud service providers. So we could say, provided they sign up to a kite mark or whatever it is, and they handle data in a particular way, then it's okay to use that body. Similarly, within the financial services sector, a code of conduct as to how we handle data and develop that within the sector, and then have it approved by regulators as the way with certainty we handle data. So it's just a thought.
And I think Jonathan, you pointed out that we were, if you go back to the 1970s, we were looking at the fair information practices principles, and it seems like those have been left by the wayside in a way and all codified now. But the codes of conduct might be more, when those begin to be published, it might be a little bit more in line with that. But it requires some approval of the regulatory authorities to actually certify organizations that, certify organizations and to be able to publish codes of conduct. And the other one, in the rule, there's certifications that processors and controllers can achieve, and it requires the supervisory authorities to certify the certifiers. So how does this work? Because on May 25th, there will be no certified, from what I can tell right now, looking at the activities of supervisory authorities and the EU Data Protection Board, which really doesn't exist yet, except in the form of the legacy working party. How does this work? May 25th, there's no codes of conduct, there's no certifications. Do you see sort of a rush on the supervisory authorities to say, certify me, and how are you going to manage all of that?
You're right. It's absolutely French that in terms of those various regulatory options, some of them will be less available on the 25th of May than other ones.
Yeah.
Absolutely right. Having contracts in place, that's in your gift to do that now. Having codes of conduct in place, that's in somebody else's gift ultimately. You have to do the hard work, the hard yards, but ultimately in terms of those being approved codes of conduct at EU level, then yes, it's unlikely that those will be in place by then because the European Data Protection Board won't be functioning. That's the body that needs to ensure that that mechanism works there. But that doesn't, I think already people are turning their minds to that. And, I think Cameron's right to say, what's the potential of codes of conduct and certification here? Because codes of conduct is one way as well for transfers, a basis for transfers, which is a new one. So,
Right.
you know, what could, in a sectoral context, somebody come up with which says, actually, this code of conduct works in particular ways, and one of those might be a transfer basis and things like that. So I think it's the ingenuity of people now to actually use these in ways that help them in terms of their regulatory obligations is going to be important. But I think as a regulator, we need the people to bring it to us. Yeah. On the privacy, I'll let you come in a minute, just to deal with the certification point. I mean, that's something which the ICO has dabbled with domestically with our privacy seals programme. So it's this idea of creating a seals framework there which uses a third party to give the seal, though it's done to standards that we approve. And part of that is to make sure that we're not fettering our statutory discretion, because clearly we might get complaints about somebody who's adopted that standard and isn't processing the personal data correctly. Then if it was our standard in the first place, then it has its own difficulties that go with that in terms of how unbiased we are. But we are very, very keen on that sort of approach and are keen to pursue that with our European colleagues to see what leverage we can get for that, because I think that's going to be a really helpful thing. And I think it goes to us rewarding the virtuous. Those who really do put effort into this and resources into it, they should have some regulatory payoff somewhere. Sorry.
So I've seen a number of the standards authorities and some of the industry associations, publishing and saying, look, we've had this code of conduct or this certification approach for many years now, and this will help you to be prepared. Anthony, is that a defense? When someone comes along and says, "Hey, I've had this. I'm adhering to this industry standard." Is that going to be a legitimate, or is compliance not necessarily equal data protection?
Yeah, I mean, the transfer would be a good example. Probably won't happen before May of next year, but if there was a certification scheme which allows you to transfer data to, say, the States, if the Privacy Shield is in as much trouble as people seem to think it's in, then that would tick the box of complying with what's known as the adequacy requirement. You've got to have some gateway in place to justify the transfer of data outside of the European Economic Area. But that by no means, you still need to satisfy yourself that the third party or the organisation that you've entrusted with your data does indeed have the technical and organisational measures in place, and that you've done sufficient amount of tire kicking around that. So it'd certainly help. It would mean that you would comply with the adequacy requirement, but you may be in trouble on other grounds.
But by the way, you brought up the Privacy Shield. Frankly, I haven't seen much use of that or the Safe Harbor before. There are alternative means for sharing information or transferring information right now, but you're sort of indicating that perhaps instead of binding corporate rules, there'll be a common set of rules or a certification standard that enables people to do that?
Well, I think the binding corporate rules is take quite a long time to get those organised and get those approved, so that they tend not to be the sort of thing that the SME community would go for. So what they typically go, if it's going to America, they would have been leaning on the Safe Harbor scheme until that was kicked into touch by the European Court of Justice. Now they can rely on the Privacy Shield. If the Privacy Shield is challenged in the courts, although, some of the stuff I've seen seems to suggest it's okay for the time being, then you would have no choice but to rely on what are known as the standard contractual clauses, and those principles will continue in the regulation. So I think having being able to meet that adequacy requirements by sending it to an organisation that's got whatever the kite mark is, the certification, the seal that's been approved by the relevant body, I think that will be an enormous help.
One of the other shortfalls with the BCR, of course, it only deals with intra-group transfers. It doesn't deal with transfers to a third party at all. And I think the other don't want to be too pessimistic or alarm mongering, but there is, of course, a challenge to the model clauses and what happens if they get knocked down in this round two. That could be, particularly in the context of Brexit, of course. Sorry if we're not moving on to that yet, but in the context of breakfast, maybe I'm a little bit late for that. In the context of Brexit, if we don't get adequacy, for whatever reason, and that's another discussion, then people are saying, well, we can rely on model clauses and it won't be it'll be burdensome, but it won't be too difficult. But if that's taken away as a route, then that really is a challenge. I can't personally see that happening, but it's quite difficult to explain that to executives when they're trying to forecast, well, what are we going to do if this happens? I just can't see it happening.
So, Jonathan, what about, this almost starts to sound a little bit like potential trade barriers, which, for the UK and, by the way, my country, the US, it sounds a little scary that, is there anything that you see that, from the, a governmental or regulatory point of view that limits the ability of countries to maybe use GDPR or data protection rules as a trade barrier?
Okay. I mean, one of the reasons why we have EU data protection laws, level data protection laws, is to make sure that domestic data protection laws didn't become non-tariff trade barriers to the free flow of information between the EU member states, and that's why the EU Data Protection Directive was introduced, to ensure there was a relatively harmonised approach. So it's not something that we're unfamiliar with in that context. I think you can look at it in a variety of different ways. I mean, it's very, very clear that, in terms of decisions about adequate levels of protection in other countries, those are made by the European Commission. So there's an element of being a political decision in there. And they're the ones who rushed to try and get the Privacy Shield in place after the Safe Harbour was struck down. So presumably there is a political will to try and make sure that data still does flow around the world. Certainly from a UK government point of view, we've made very clear that when we leave the European Union, we don't want data protection laws to become a barrier to the flow of information. So, we're going to do what we need to do to make sure that we've got appropriate standard of data protection law in place there. I think, though, if you really think about this in the long term, isn't this just ripe territory for international treaties and things like that?
It is,
that take us out of this a little bit. And so I just think that, in the longer term, that must be a direction of travel here. We've seen the way the digital economy works. It's not constrained by national boundaries or anything like that. It's just changed, and maybe we just need to be more creative in terms of our international level instruments now.
Yeah.
Right. It is interesting, by the way, Britain founded the predecessor to the International Maritime Organization, but it didn't become a UN organization until the 1970s. I think we'd had seafaring since before then. So sometimes these things take a little while to move into, fully into true international conventions. But you're right, it is ripe for it. We have the OECD Convention on Anti-Corruption, which deals with all the bribery laws. It looks like, the EU may be helping us take a step in that direction. Yeah, it's possible. Certainly.
Well, I was just going to sort of cast our minds back to the pre-Edward Snowden days, whenever the buzzword was interoperability. And there was a real sort of optimism around that time that we could find a sort of common bridge between the emerging US data privacy laws as they were now and the EU data privacy laws and the APEC framework to say, is there a way, because they're all pretty similar, to be honest, if you look at them, is there a way that we can come to a common arrangement here to allow international transfer of data? Because don't forget, we're focusing on the EU, but for organisations like us, we've got issues outside of the EU. The EU is just one of our issues that we need to deal with. And one of the difficulties we're facing is there is a common trend, particularly among some Asian jurisdictions to have data localization laws which are bringing the data back into the country. That's not necessarily due to data privacy concerns. It's other issues that are driving that, but it's a real problem that has to be sorted.
Yeah, data sovereignty and things like that.
Yeah.
So, before we run out of time, I think the issue of technology evolution, which this gentleman here brought up at the front, we could do probably a whole day on that, not just a few minutes. But Jonathan, you very early pointed out the evolution, how technology has evolved. GDPR highlights that there are other types of data. I mean, in the past, we've really looked at personal information as being names, addresses, telephone numbers, social security, driver's license, things of that nature, medical records, and so on. So very clear, structured types of data. But now we see Google, Facebook, Microsoft and others building profiles. And this profile, I would say behavioral profiles on all of us that are certainly very valuable, key to their ability to provide services the way that they have provided them, and also very critical to their revenue models. And every one of us, I think, even banks, insurance companies, all of us are now engaged in that just a little bit, trying to understand our customers, understand our employees, and the risk of these profiles, which are not necessarily a structured data, and it's something that changes every day, and new technology comes along to improve that, including AI. In fact, Facebook and Google and so on couldn't deliver what they do without AI these days. So what do we do, to sort of keep up with this? And, if you're looking at, artificial intelligence, which pulls in data all over the place, I think, HSBC, I'm sure, is doing experiments with AI, and how do we keep up with that?
Artificial intelligence is one of those sort of buzzwords that's been floating around for many years. I was an engineer before I became a lawyer. In 1993, I went on a course on artificial intelligence as a process engineer, and sort of concluded at that time it was mainly just sort of expert systems, rule-based stuff. And I think that it has been like that for quite a while. So people use the term AI quite loosely, where it's really, to my mind, it's either very often automated decision-making based on a set of solid rules, or it's analytics, where you're using patterns to discover information that would otherwise be hidden. But I think in the middle there, the artificial intelligence, where a machine is truly thinking like a human and truly making decisions, I think is emerging, and it's a really powerful area with very significant consequences way beyond data privacy. But I think that for the data privacy perspective, there are rules around this on profiling and automated decision making contained in the GDPR. It's a challenge to apply those to what people do, and I think that to deal with it, I think we need a shift in the way we think about data privacy. And we've already seen some of these activities. The World Economic Forum did a few years ago, the control shift thing through Facebook. It's really looking at, we need to think differently at how we look at data, that there's a collective good in the use of data in this way, and that should be recognised, provided it's done in a proportionate way. But it's a bit of a shift. Then there's a whole sort of agenda trying to push that forward, which I think is needed to try and get some rules with a different way of thinking there.
Yeah, I mean, I'd agree. I mean, as you said, French, we don't have all day to go at this question. But it's a really prescient question, because our House of Lords has an inquiry going on at the moment, which is on artificial intelligence. So if you're interested in the ICO's views, go to our website. You'll see our response to that inquiry, and the Commissioner gave evidence the other week in person to that committee. But it is a really interesting point here about one, which you're touching on there, in terms of how do we regulate decisions that are made as a result of artificial intelligence. How do we perhaps regulate things which are perhaps not applying the data straight back to me, but it's information derived from my data that's applied to people like me, and to what extent is that personal data about me or not. And there's an increased debate in the UK, and certainly our government's thinking about this, about data ethics. And is there a space of data ethics which lives beyond the narrow regulation of personal data? And so we come up with ethical standards in terms of the way AI and data should be used in that wider context. And I think probably we're finding there is a space there which is above data protection regulation, but there still should be some ethical points of principle that people follow. And it goes back to that point about public trust and confidence. This AI stuff, it can sound pretty scary to individuals.
No, Stephen Hawkins warns us that it's that it's an existential threat. Elon Musk says we have to regulate it. So it's but no one really knows what any of that means. I don't think. It does raise new questions too, just from a very practical standpoint of what is personal data. Is it personal data that the Nest device in your home detects how many cooking oils are in the air? At any given time, and starts building that into a profile of your, of your habits and when you eat dinner and when you don't eat and so on like that, how often you appear to go out to eat. So all of this is just, we could probably raise more questions than answers at this point. So, we're really at the end of our time, but I would like if each of our panelists could share just a key takeaway, if for our audience, if getting back to your office tomorrow, what might be something that would be practical that you could take a step on towards improving your ability to meet the new requirements for GDPR. So. Besides calling outside counsel, what might be something, Anthony, from a contractual standpoint?
Yeah, I mean, I don't think it's a case of May of next year brace for impact. I think all organisations have to go on a journey to achieve a sensible level of compliance and continue that. So I think looking at the sort of key principles of around accountability and transparency, it's putting practical measures in place to deliver on those requirements. A lot of which will be within an organisation, making sure that the individuals, not just senior management, but all the individuals in the organisation, understand the role that they have to play in keeping the data secure and not availing themselves of shadow cloud or whatever it is, but building the policies and the procedures and sort of training programs around that, so that is fixed as much as it can be between now and May of next year, but it's going to be an ongoing rolling requirement.
Certainly.
Yeah, I mean, I would focus on what you want to be able to do in May 2018. It's not very far away, and the journey will continue after there, but that's certainly a very important stop-off point. And at that point, you need to be able to demonstrate compliance. So if Jonathan comes and knocks on your door, well, what are you going to say? This is what we've done. It won't be perfect, and I would recommend reading the ICO guidance, to be honest, because I've seen so many very complex pieces of guidance from consultants who've all of a sudden become GDPR experts and quite often get it wrong, to be absolutely honest.
Right here.
That's the next one, sorry. But just focus on the ICO guidance and just practical things. You need a record of processing. You need to make sure your notices are up to date. You need to think about when you rely on consent and can you stop it. There's about 8 things that you need to do, and it's really quite practical. Get that packaged up and in place for May 2018. Identify areas where you need to improve maturity and go forward on that basis. A lot of it's just simple, good practice.
Yeah. I mean, I'd agree with that. I mean, a lot of the laws have common features, okay, and that's the same. So organisations that have been doing the right thing, doing a good job so far, will be well placed with the change. One of the things that I've been surprised about, and I spoke at a conference again yesterday when the audience were polled about this, are the number of people who were not confident that they knew all the data they actually held in the organisation and where it was. So unless you actually understand that basic point about what do we hold, what basis did we obtain it, what other provisions surround it, is this something that's being processed by a cloud service provider or something like that, unless you do that basic data audit, you aren't going to be able to answer all those questions that you need to pose yourself now. So understanding that's really important. And my key takeaway, the clock's ticking, don't delay, act today.
And the one thing that I'll add, really, that backs up this is one of the things I've noticed in this in talking to a number of people about GDPR here at the conference. We need to think internally within our companies of the shift from more of a principles base to really a codification of the law, and that applies inside as well. I think many companies have not really taken the point of view of a third line for GDPR specifically. There may be a third line for overall security, a third line for overall risk, but the law is very clear about data protection officers auditing ensuring that they're auditing the compliance activities. So there is a third line requirement, and that is a little bit different than what we've done, shifting from just a compliance regimen to an actual inspection and audit regimen. It's two different things. So it's something to think about. Is your organization ready for that? And yesterday at our GDPR panel, it became very apparent that many in the audience said that, hey, we have a point person for GDPR, a potential DPO, if not an actual DPO. But the audit resources backing that person up were not really fully dedicated. So that's something to think about. Well, thank you very much, gentlemen, and thank you for our attendees, particularly those who gave us these challenging questions. And I hope you enjoy the rest of the summit. And let's thank our panelists. All right. Thank you.